He is not on it. No objection, guys. They added to that.
All right, the court calls case number 04-129-291. This is Midland Credit Management versus Vivian Booker. Matter was adjourned from a previous date until today's date. This is regarding an objection to a writ of garnishment. It has the garnishee name as Midland Credit Management. And let's have your appearance at this time for the plaintiff, please. For the plaintiff on Midland. Right, do I have defendant Vivian Booker? Vivian Booker. All right, the court will recall that shortly. Check. See if there's someone that arrives on that one. The court now calls case number 21-240-315. This is Jessica Floyd versus the budget lot. The matter is before the court, set on today for a pretrial conference. It was adjourned. Looks like from a previous conference date. Your appearance for Jessica Floyd or Ms. Floyd, if you're here, please state your name for the record at this time. Jessica Floyd, I'm looking for Jessica Floyd. Do I have someone representing the budget lot, please? Counsel for the budget lot. All right, the court now calls case number 21-165-777. This is Mobile MRI Staffing LLC versus City of Detroit. The matter is set on for a hearing on today's date. Your appearance for the plaintiff at this time, please. You're muted, so unmute yourself, counsel.
My apologies. Good morning, Your Honor. Danny J. Joe P80645 up here on behalf of plaintiff.
And good morning to you, sir. For the defendant, City of Detroit, in this matter, counsel, your appearance, please.
Good morning, Your Honor. Robin Brooks on behalf of the City of Detroit, P47787.
All right, and thank you, Ms. Brooks, and good morning to you as well, ma'am. All right, so I see that there is, there's been a responsive pleading in this matter. I'm not seeing that there has been any schedule put on this case. Somebody update me at this time if you will.
Your Honor, that is correct. We do need discovery in this matter. There has been no scheduling order submitted to us as of yet. The City of Detroit has filed their initial disclosures with the plaintiff. We have not received their initial disclosures back as of this moment.
All right. And I see in your response and pleading that you reserved additional offenses in demand for compulsory joinder. Are there any joinder issues that are prevalent at this time, to your knowledge, ma'am?
To my knowledge, I don't know, but we have to plead it or lose it.
Absolutely, got you. All right. Just if that was on the horizon, wanted to try and address some of that at this point. All right, Mr. Jadon, that's about the size of things as you understand it as well, sir.
Yes, Your Honor.
So I'm thinking a 60-day horizon for discovery in this matter, and see how things move along. Obviously, if things come up, then when I review this at the end of that period, I'll be able to address whether additional discovery might be needed. I'm going to go ahead and open that window for a period of 60 days. It will actually be through the date of your return. And so that date is going to be
316. You want a 2 month phase?
just beyond 60 days.
316. You want to try 316?
316 is the date that I'm looking at, 3/16/2022, and that's going to be at 9:30 a.m. That's going to be treated as a pretrial conference. I would note that you may file motions and set them for hearing on that date if you wish to do so, as long as you give the other side 7 days notice prior to the hearing. I will hear your motion on the 16th of March. That doesn't forestall you from filing motions in the future, but if in the course of discovery, there's something that you wish to bring to the court, whether dispositive or non-dispositive, so long as you give the other side at least 7 days notice before the hearing, I will hear it on the 16th of March 2022. You'll receive an order of discovery from the court with the information that I've set forth. Discovery is open through the date of your return. It's 3/16/22 at 9:30 a.m. I do wish you well. Any additional matters that I need to address at this time, sir?
Nothing, Your Honor.
Counsel?
Your Honor, only that we would get those initial disclosures immediately because we submitted ours since
Yep,
November.
I'll send them right away, Robin.
Thank you.
All right, excellent, excellent. And of course, I always like that kind of, moving everything that can be moved. It's, we don't need to waste time on that. There'll probably be some things that will come up that will take time. Stuff that doesn't take time, let's just get that out of the way. And I'll review everything on the 16th. And again, as I mentioned, I'll hear your motions if you file somebody. And we'll see what this case is. We'll get a better picture of what the case is at that time.
Awesome.
So I wish you well. Good day to the two of you.
Thank you.
Your Honor.
Have a good day.
The court at this time calls case number 21-240431. This is Molly Howard versus Michigan Auto Recovery. The matter is before the court set on for a hearing on today's date. This appears to be a status scheduling conference. Your appearance, if either Molly Howard or your appearance for Howard.
Marty Howard, yes, I'm here.
All right, good morning to you, sir. And I note your appearance at this time. All right, for the defendant in this matter, you make this time your appearance.
Good morning, Your Honor. Thomas Stidham, P56504, appearing on behalf of the defendant, Michigan Auto Recovery Service Incorporated. With me today, also, Your Honor, is the president, Mr. Gregory Arrigo.
All right, thank you, counsel, and good morning to you, Mr. Stedman. All right, so this looks like this started out as a claim that was filed in the small claims court and then removed to this court. And the claimed amount in this matter is in the nature of some $650. In reviewing the matter, I did look and I saw that that defendant, of course, filed their answer affirmative defenses. And there's not a counterclaim that I'm seeing in this matter. Is this something that has any reasonable likelihood of resolution? I don't want to put it through the entire process unless we have to. This looks like it has something to do with a claim that a vehicle was towed, that something was stolen from the vehicle, et cetera, and that it resulted in some $650 of loss. That's what the claim is in this matter. Mr. Stidham, anything, your reaction as to what the court has just indicated?
Yes, Your Honor. I would just note for the court, and Mr. Howard can certainly confirm this, the parties, I can confirm, I think it was sometime in the fall, the defendant did extend a settlement offer to the plaintiff, which was rejected. And since that time, because we haven't had a scheduling order, we haven't issued any, I would just need whatever receipts or whatever. I'm not clear even what is alleged to have been missing. So I would just request, if the court is so inclined to, if the parties can't resolve it on our own, then to at least allow us 30 days for discovery, just so I can get the documents or whatever whatever the plaintiff is alleging.
All right, got you, Mr. Stigg.
Excuse me, Your Honor.
Yeah, I'm coming to you, Mr. Howard. Mr. Howard, what did you want to say at this time, sir?
Okay, sir, I've been going through this since like February the 5th of what, 20 or 19 or 20? I think it's 20. I've submitted all the paperwork. I've took my receipt from my Harbor Freight receipt to them to show the things that were in my truck at the point in time of my truck being towed for no reason. And I've been back and forth up there. I dealt with the owner having COVID 3, 4, 5 times. I've gave him time, months, and I would go back up there. Like I showed them, they have all the paperwork. I submitted the paperwork to the court. Everything. I've been going through this forever. Like I explained to the owner when I finally called him up there, he spoke with. Those are the things that were in my truck. I was just starting to work on a home I purchased, and I had no reason to play with my brother's receipt right up there. He asked when he asked the lady who is behind the window, asked me, "Do you have a receipt?" I contacted Harbor Freight to send me a receipt from them of the items that were in my truck and that were taken. Attorney contacted me and offered me $200. I explained to him, I'm not about to accept. I just don't want no money. I need my tools because I'm working on my house, and I showed them what was taken out of my truck.
I'm stopping you right now, Mr. Howard. I can't let you try the case in front of me. So,
I'm sorry.
What are you asking me to do is to decide this case today? Because you know I can't do that. You know, you file a lawsuit, and when you file a lawsuit, that gives the other party the right to defend and start a number of different processes. It does sound like a case that should be settled. I can't force either side to do that. You know, I started out by saying that we all talked about it. Obviously, those discussions did not lead to a way of getting it resolved, so it's got to be litigated. This is a process that's involved here. And while you, of course, indicate to me that this has been going on for a significant period of time, I know that you filed your paperwork with the court back in, I think, May or so of 2021. And then it was removed from the small claims over to this division. So this is your first hearing in front of this court. And of course, when you file a lawsuit, you know that that's a process that's involved. I do think that is something that the parties could or should resolve, but I can't force your hand to do that, Mr. Howard, nor can I force the other side's hand. So it kind of has to be, it has to be litigated. And if the parties work it out, they work it out. If not, you end up with a trial in front of me at some point after the normal course that these kind of cases go through. So what I'm going to do is I'm going to set a schedule, the lowest period of time that I would typically give to allow for discovery, exchange of information under the authority of the court between the parties. The plaintiff may seek information, the defendant may seek information, and is allowed by a court order now. I'm going to allow for a 45-day period of discovery. So if there are interrogatories or questions that are submitted by either side, those questions have to be answered. Requests for documents have to be responded to. If there are requests to admit, those have to be responded to as well. Even if there's a request for a deposition, for someone to sit down and give testimony, that has to be complied with under this order as well. I'm going to set a pretrial conference date just beyond the 45-day period. And I will review this case at that time to see exactly where the case is, whether I need to set it for trial. And if so, I will set it for trial. And it won't be long after that date that the court will set it up for a trial date. Given the nature of this case, it doesn't involve a whole lot of money. So, so the next action date in this matter is going to be 2/27.
2/27, 2/22.
2/22, I'm sorry, 2/22/22, all twos, and that's going to be at 9:30 a.m. February 22nd, 2022, 9:30 a.m. Discovery is open through that time. As always, I will allow the parties to file motions before the court if you wish to do so, and set the motion on for hearing on the 22nd of February 2022 at 9:30. So long as if you file that motion, you give the other side at least 7 days to respond to the motion. You'll get a written order in the mail from me with the information that I've indicated today, as well as with the court date as to when you are to return. It will be a virtual hearing, so return in the same Zoom that you came into today. All right, that's the order of the court. Like I said, you received something in writing from the in the mail. I wish both sides well. Good day to you.
Thank you, Your Honor. Have a good day.
Right. Thank you. Court now calls case number 02-114423. This is CFC Financial Corporation versus Sheila Fields. The matter is before the court on the following of objections to a writ of garnishment. Record should reflect in this matter that a judgment was entered on the 1st of November 2022 for $4,404.87. Subsequent to that time, that judgment was renewed, and the plaintiff has filed a writ of garnishment as to the third-party withholding unit of the Michigan Department of Treasury. All right, your appearance for the plaintiff in this matter, please.
Matthew Kuipers on behalf of plaintiff, Your Honor, P71248.
All right, thank you, Mr. Kuipers, and good morning to you. Do I have Sheila Fields on the Zoom or someone representing Ms. Fields? Sheila Fields or anyone representing Ms. Fields? I see someone on an iPhone. If that's you, Ms. Fields, you would have to unmute yourself and let me know that you're there. I'm looking for Sheila Fields, a person residing on Pearson Street in the city of Detroit. Right, the court, the matter was set up for 10 o'clock a.m. and the court has reviewed the objections wherein the plaintiff, the petitioner says the writ was not properly issued or is otherwise invalid. And she checks number 2 on the objection form. I object to the written statement I received from the creditor because the balance of the judgment is wrong. And she attaches a statement. My name is Sheila Fields. I need to stop garnishment on my tax refund credit. I need the money for my kids. I live on a certain address 20 years ago. I need to stop them from taking my money. Financial corp, I need to stop. 20 years ago, I paid them now. All right. So our objection seems to sound in the fact that it's been going on for a significant period of time, and also that she would like an accounting as to the amount, and then thirdly that the income tax return would pose a hardship on her financially. So once again, is Ms. Fields here? Sheila Fields. Sheila Fields. All right. It appears that she's not here for this hearing. Counsel, your position at this time.
Judge, it's the plaintiff's position that the simple fact that the defendant didn't show up for the hearing is cause for the objection to the tax garnishment to be denied. Furthermore, based on the records by plaintiff, at least those filed on the tax garnishment filed September 30, 2021, there's only been $99 in payments made on this account. The judgment's been around since November of 2002. So that would be the accounting that the plaintiff would provide to the defendant. I don't see any defect or irregularity in the actual garnishment itself. And while the tax garnishment may impose a burden on the defendant, the only thing really the defendant, I guess, possibly could do is request an installment payment order. But as the court knows, installment payment orders don't prevent income tax garnishment. So for all those reasons, plaintiff's requesting the objection be denied.
All right, the court has reviewed all of these circumstances. It would be helpful if the defendant was present, but given the circumstances on balance, there clearly appears to be an outstanding balance on the judgment. With that being the case, the plaintiff would have the right to seek relief by way of objection, strike that by way of a garnishment with the Michigan Department of Treasury. And in as much as they have done the same, and in as much as the defendant has not appeared and not provided on its face any reasonable objection or objection allowed by law to the writ of garnishment, the court will deny the objections and find that they're invalid and will allow the garnishment to stand. Signing the order consistent therewith at this time. Thank you, counsel. Good day to you.
Thank you, Judge.
All right, this is case number. This is case number 21-164442. This is Credit Acceptance Corporation versus Albert Martin Alexander III. The matter is before the court, set on for a hearing after the filing of a responsive pleading to the complaint. The court has set the matter up for a scheduling hearing on today's date. Your appearance for the plaintiff or plaintiff, if your appearance for the plaintiff at this time, please.
Thank you, Judge. May it please the court, I'm Attorney Richard Grissom. I am the attorney of record for the plaintiff, and my bar number is 35222.
All right, thank you, Mr. Rosen, and good morning to you, sir. I'm looking now for Mr. Albert Alexander Martin III and or any person representing this department. Please say something at this time.
I'm here, Your Honor. How you doing today?
I'm good, Mr. Martin. Good morning to you, sir. All right. Of course, as you know, this is a complaint that has been filed against you, alleging that there is an indebtedness in the amount of some $12,853.67. This appears to be in regard to the purchase of a vehicle with the use of credit. It looks like the purchase date was on or about the 26th of August, 2018. All right, so I've seen your answer to the complaint in this matter, and while you stated a number of things here. So typically what I would do is set this up for a schedule to get mutually more information and try to figure out a way to get this to a conclusion. So what is are you willing to talk about trying to get this resolved in some kind of way? Tell me what your key issue is, right quick, sir.
Well, Your Honor, I am available to solve all of this, and I just wanted to know what would they be able to settle for going forward.
All right. All right. So I will take a moment, just a moment for yourself and Mr. Rosen to have a conversation in that regard. I know that the claim is obviously a substantial amount in excess of $12,000. You certainly may want to make an offer or try to talk this through and see if he has the authority to come to where you might want to come to on this. And then if that can't be worked out, I will set up some type of schedule. If it can be resolved, you typically can either work out a payment plan with Mr. Rosen, or you can petition the court for a payment plan if you reach a number that resolves the case for you. So I want to take just a few moments to place you in a breakout room with Mr. Rosen, just to see if you can discuss it and see if there are any possibilities of getting it resolved. And then you can come back in after that discussion. If you got it resolved, that's fine. If not, the court will figure out the next process for this case. So Mr. Rosen,
All right, thank you, Judge.
Received the notification, and you're receiving a notification at this time. Breakout room. All right, you got your notification. All right, this is case number 21-240690. This is Gallery versus Protector Window and Door. The matter is before the court, set on for a pretrial here. It looks like this initially started in the small claims court and was removed to the general civil division. The claim that was brought in this matter alleges damages of $1,000 plus court costs. Just one moment. Indicates that this had to do with the installation of a door and damage in relationship to that particular door. All right, do I have Gail Reed or someone representing this Reed on this Zoom at this time? Say something.
Yes, Your Honor, this is Gail Reed.
All right, good morning to you, Ms. Reed.
Good morning.
Thank you for being here. Just one moment. All right, thank you. And your appearance for Protector Window and Door.
Good morning, Your Honor. Michael Norman, P75844, on behalf of Protector.
All right, thank you, Mr. Norman, and good morning to you, sir. All right, so have both sides tried to talk about this at all to see if this might be resolved? I'm kind of directing that to you, Mr. Norman.
We have not had a conversation. I would be happy to talk to Ms. Reed regarding potential resolution, although I don't know how likely it would be in this case.
Gotcha. Yeah, that's typically a reasonable, at least starting place to see if the parties can reach an accommodation that works for the parties mutually. Usually that means that it's a little bit of something that both sides like and a little bit of something that both sides don't like. That's usually what the nature of resolution is. So I want to start there, Ms. Reed, and you and the attorney talk. Obviously, we'd like to force anybody's hand. This is just a conversation to say how you might resolve the case. Obviously, most cases in America are resolved because people work out their differences in some kind of way. Then there are some cases that are tried, heard, so on and so forth. A lot of times the impetus behind trying to get it resolved is that you have a greater predictability, you have a greater predictability as to what happens. And number one, and number two, you have finality. If they can resolve it, that's the end of it. They know what's going to happen. That's a part of the motivation for resolving things. Litigating stuff, and sometimes it drags out a little bit, and people oftentimes want to go on with their life. I'm here every day, so I hear cases all day, every day. So it doesn't matter a whole lot in that way. But I do like to see parties able to come together and try to get things worked out, especially when you're not talking about a $10,000 or $20,000 claim. I know that it's matters of principle. It's $1,000 matters of principle, but then you have to think about the big picture and if there are ways to come to a reasonable resolution. Again, that makes both sides satisfied about something, both sides unhappy about something. That's usually a good. It's usually a good resolution. I know it sounds crazy, but that's usually a good resolution. So take a moment to talk about it. I will be here on your return. I'm going to put you in breakout room number 2, and let's see if we can get anywhere with this today. If not, I won't be mad at anybody. I hope that you get it worked out. If not, we'll figure out a way as to the next steps in this particular.
Your Honor, after we speak, do we join back into this meeting or, okay.
Either way, you would come back into the meeting. Try to get it worked out. Come back into the meeting. If you don't get it worked out, come back into
okay.
And I'll come back to you, Matt. Right. So,
thank you.
And Madam Counsel, which matter are you on?
Yes, Your Honor. I'm here for case 181-49014. I'm here on behalf of the plaintiff, Auto Track.
Yeah. The one you said it wasn't on there?
That's that add-on?
Yeah.
Okay, got it. This is case number 18-149014. This is Auto Track C, doing business as the Cumming Auto Trust versus Rhonda Jones. The matter is before the court on the filing of objections to a writ of garnishment. Your appearance for the record at this time, Madam Counsel.
Yes, thank you, Your Honor. This is Natasha Dixon on behalf of the plaintiff, Auto Track LLC. My P number is 82333.
All right, and thank you, Madam Counsel, and good morning to you. Do I have Rhonda Jones on the Zoom? Say something if you're here.
Yes, I'm here, Rhonda Jones.
All right, thank you, Ms. Jones, and good morning to you, ma'am. I did receive the objections to the writ of garnishment in this matter, and I also received a motion affidavit for installment payments. All right, with regard to the objections to the writ of garnishment, I see that this is in relation to St. John Hospital and Medical Center, and in looking at this, it says the objection states that the writ was not properly issued or otherwise invalid. And it further states that the amount that was agreed upon, I can no longer, I can't make out that last word, but I'm assuming is I can no longer pay. What is that?
I can no longer afford the amount that I consented to in 2018.
I was looking for that word. That's what that word is for. All right. So you're being garnished right now at your place of employment. Is that correct?
Correct.
All right. How long has that been going on?
It's just been one payment.
All right. All right. And how much money was taken from you in that one payment?
$459.
All right. So you get paid every other week or
Bi-weekly.
Bi-weekly? Mm-hmm. So technically speaking, that would be the garnishment amount would be somewhere in the nature of $800 to $900 a month under this this garnishment situation.
Correct.
So you said that you were no longer able to afford the amount that you agreed upon. What was the agreement? Tell me about that.
I don't remember the actual amount that I consented to in 2018. They reached out to me for the past year or so regarding that amount, and I had explained to them that circumstances had changed since 2018. I'm currently now like a full-time student. I've been for the past year, and I was living with my parents at that time. I consented to pay that amount. I don't have that amount with me. It wasn't provided in the paperwork, but I did try to resolve it by asking them to reduce the amount. But unfortunately, because I did consent in 2018 to that amount, they stated that they were unable to agree upon a different amount.
Right, and looks like the rate that I saw was $325 a month. That was consented to, looks like somewhere around March 30th of 2021. All right. So you were paying, but you you ended up stop paying because of circumstances. That would happen.
Correct.
So once that happened, of course, that's why they had the right to file a garnishment because you were on payment. Okay, Madam Counsel, your response in regard to this matter.
Yes, Your Honor, thank you. I did want to start off by saying we did indeed, of course, file a wage garnishment on or about August 24th of 2021. We actually haven't received any garnishment payments so far, so I'm not sure if they're being withheld, by the employer and are in the process. But I just wanted to, as of today, as of right now, we have not received any garnishment payments so far. And like Ms. Jones was saying, this is about the consent judgment, and like you just said, Your Honor, it was $325 per month. Beginning April 27th of 2018, and the last payment was made on July 11th of 2018. And if she, I believe we also received the PPO where she's requesting to pay $100 every 2 weeks, and we did not object to that. We are okay with that. We did file a response to the objections that she had, basically saying that it did not fall within what she was saying did not fall within any of the MCR 3.101K2 objection guidelines. So just based on that, we filed a response. I mean, if she wants to do an installment payment plan, we are fine with that, but just we are okay with that. But yeah,
I'm sorry. Actually, that was a month. That was $100 a month that I can actually afford as of right now. I'm still recovering from the pandemic, being in the healthcare. So I'm just now recovering from different loans that I had to pay out bi-weekly. So that amount I put as 100 for installments was for a monthly amount, just for clarification.
Okay.
I don't know that with the judgment amount and where the judgment amount is that $100 is a reasonable payment. Moreover, where you had $325 a month as the agreed upon amount, you're asking the court to reduce that amount by more than 2/3. And then finally, the garnishment, if I allow the garnishment to stay in place, it would take $900 from you a month. So you're talking 900 versus the 325, or you're talking 900 versus basically a $200 a month payment. I understand the other debts and obligations, but the number has to somehow be in relationship to the judgment balance. But I listen. The biggest challenge that you have here has already been resolved. That is that you don't really have at law a basis for objecting to a writ of garnishment. So that's your biggest challenge. But given the circumstances, I think that it's reasonable to allow you to pay it voluntarily rather than the $900 a month. But at law, you really don't have anything to kind of like set that aside. And it's good for the posture that the plaintiff is taking in this, but I would likely set it aside anyway, because that would pose a significant hardship. But that shows you what the law allows when there's a judgment. You allow that garnishment, and garnishment is merciless.
Your Honor, can I add one thing to that amount? I'm sorry, that amount was, I think that they garnished like 25%. So that was 25% of an amount that a net pay that I will not be receiving. So that amount that they garnished was from additional funds put in from tuition reimbursement. So it may be lower my next check. So I net pay $1,700. With this specific paycheck, it was a lot more. It was an extra $1,600 on this check. So it'd actually be less this upcoming for garnishment. If they were to garnish, the percent would definitely go down dramatically.
Yeah, but well, either way, you don't want to be under that type of situation. And
correct.
You indicate that you typically net about 1,700 or so.
Correct.
Yeah. So if you take you take 25% of that, you're still in the neighborhood of some $300 or so per pay period. $600-700 a month is yeah. I mean that's what we're dealing with basis versus coming to the court and trying to get it resolved in some number lowered. And I'm going to lower the number. I'm going to take the garnishment off. The funds that are withheld, whatever they took already, I'll allow that to be applied towards the judgment. And I'll stop the garnishment, and there will be no further garnishments. And then I'll set up a payment date. Counsel, as to the amount. Anything further in regard to the amount that she wishes to pay?
No, Your Honor. I mean, as long as she makes it on time, we are okay with that. And of course, if there's ever a time in the future that she can, pay more, I would certainly encourage that, considering the balance, which is just to add, that's as of today, the balance is $12,004.06. So that's 12,004.06. That's the balance as of today. So of course, if there's ever a time you can pay more, I would, you can do that.
So she's indicating to the court, where her petition says the $100 every 2 weeks. She says she wants to do that for $100 a month. Your thoughts on that?
Yeah, I mean, I would be considering the balance. I would be looking for at least, and the consent judgment was for $325. Maybe if can you pay 200 per month just to kind of have a middle ground between the two, the 100 and the 325? Are you able to pay 200? And of course, we want to have it so that you are able to make payments reasonably, so we don't come back here, so that's really the purpose. So are you able to do 200?
Comfortably, I don't want to be in this situation again. I agreed upon an amount that obviously my circumstances had changed and I was not able to change that,
Let me stop you. You've articulated your position very well. I mean, it's hard to get below $200 with this type of debt.
I understand.
I'm very cautiously taking a look at all of this because I understand you started out showing a willingness to want to get this resolved, and you set the payment at 325. Things happen, so on and so forth. And then I also have here, and that's not always the case. I have here a plaintiff attorney who is saying that they're willing to work with this. Oftentimes, where there has been a lapse in payment, they come in and they say, Judge, that garnishment should stay in place because she hasn't paid since such a date. So obviously, there's some effort to try to make this work out. So, I think that the $200 amount is quite reasonable. And I understand that poses a little bit of hardship. What I'll do, I'll go ahead and I'll set it at 150, and I'll make it reviewable in 6 months. So I'll set it here from 6 months out, and I'll review as to whether it should be increased from that amount. And that'll give you a little bit of a window to try and deal with this. And the reason that we're having this discussion is because of how big the judgment amount is. If your judgment amount was much less than that, then we could, you could talk about a whole bunch of things. But with that amount of judgment, you got interest accruing. So part of this, the court has to set some amount of reason to get it paid off. And also, the court is not interested in you being in a position where, you're not able to chop at this. So what's happening is that interest is continuously being piled on as your payment is so low. That's a part of the consideration. So I'll go ahead and set it at this point. I'll set it at 150.
Okay.
I'll put the commencement date for the partial payment order. I'm going to set just one moment. I'll go ahead and set that commencement date as 28 January, 1/28/22, and or about that time each month until the balance is satisfied. And I'm noting that this will be reviewed in 6 months.
Okay.
So we're gonna make sure that you get a date for the review of this matter. All right. So I wish both sides well. You receive a copy of my orders.
Excuse me, man.
Right, or you'll receive a copy in the mail.
Hey, y'all.
Okay. Your Honor, actually, if I may, I just have a question. Since, like I was saying, we haven't received.
I'm sorry, I thought that was somebody else talking. Go ahead, Counsel.
Yes, thank you, Your Honor. I just had a question. So, like I said previously, that we haven't received any garnishment funds so far. And they might be in the process. We haven't received a disclosure from her employer, so they might be in the process. We might receive something soon. So if we do receive that, are you just to kind of clarify? You said we can keep those funds and, of course, apply that toward the balance, so it's lowered.
Yes, what I'm signing my order says that the garnishee will immediately release all withheld funds to plaintiff in this matter, and then and thereafter the garnishment will stop. So any funds that they've already withheld, they will have to release those funds.
You're welcome.
To the plaintiff. And then
Okay.
the partial payment order.
Okay, understood. Thank you, Honor.
All right, wish both sides well.
Thank you.
Thank you, Your Honor.
All right, thank you. I'm already decided. So Mr. Rosen, thank you for your patience, sir, and welcome back. Also, do I have Mr. Marvin back at this time? Marvin, you there, sir? Mark?
Yep, I'm here.
All right, thank you, sir. Okay, if you will, sir.
All right, Judge?
Yes, sir. Mr. Rosen.
Richard Rusin for the record. I have spoken to Mr. Martin in the breakout room. The two of us have agreed to enter into a consent judgment. And the amount of the plaintiff's claim, I read over my proposed order to Mr. Martin, and that with the entry of the consent judgment, the parties have further agreed that Mr. Martin will pay $200 a month beginning February 15, 2022. That will be put right on the proposed order. I obtained Mr. Martin's email address in the breakout room so that I can email the proposed order to him. And I explained to Mr. Martin how he can make payments, how he can possibly call my office to sell the whole case in whole. And that is the sum and substance of what we have. So based on that settlement, I rest this time.
Mr. Martin, the terms as set forth on this record, is that the sum of the discussions and the agreement that was reached in the breakout room, sir?
Yes, Your Honor, it was.
All right. Anything you needed to bring to my attention at this time, if you wanted to, go ahead, sir.
Not at the moment.
All right. All right. Well, I think that's a reasonable way to resolve it. And I'm glad that the parties had an arm's length discussion regarding this matter. Thank you, Mr. Rosen, for guiding that discussion. And thank you, Mr. Martin, for your engagement to try and get this resolved. I will sign the order consistent with the agreement. And I wish you well, Mr. Martin, as you go forward to get this finally resolved, sir. Thank you, Mr. Rosen.
Yeah, one last thing.
Thank you,
Go.
Mr. Rosen?
Yeah, I want to tell you, I've been before that new judge in Harper Woods a couple of times, and just for my 2 cents, I think she's got the right stuff.
I thank you. Don't make that tear come up in the corner of my eye, but I think you know. I think you.
Well,
have
now it's
some-
on YouTube.
Yeah, but I think you have some insight into how proud a dad might be, boy. I tell you.
All right, well, this time the record is perfected.
Thank you. I appreciate that. All right, thank you. All right, and then thank you for your patience, Ms. Reed and Mr. Norman. Good morning again to you. I know you've been in a breakout room. And if you will, counsel, update me at this time. So.
Yes, Your Honor. I spoke to Ms. Reed. She is I gave her my email address. She's going to email me pictures of the damage she alleges so I can review them with my client and then talk to her about whether or not we can reach a resolution. So I just request another pretrial date, Your Honor.
That makes sense. Ms. Reed, so my thought is to set it over for about 30 days just to take a review of where things are at that time. We have to go forward in other ways, and then I'll be able to get right at the case at that time. That makes sense to you, Ms. Reed?
You said 30 days?
Yeah, that's what.
So what?
I could bring it back sooner than that if, Mr. Norman, you think, 2 or 3 weeks or, that time would give enough review time, I'll bring it back soon.
Yeah, I mean, as long as she sends over the photos, Your Honor, 2 to 3 weeks will be fine.
Your Honor, I have a question. Whatever I submit to
One second,
Oh.
Ms. Reed. Yeah,
Okay.
so basically what I'd be looking at doing is just setting it over for the 27th of January. Either the 27th or the 31st.
31st is better.
My clerk said the 31st. So
Yes.
131 will be the date. The clerk has spoken. All right, so that's what we'll be looking at 9:30. Ms. Reed, go ahead now.
Whatever I submit to the defendant's attorney, do I also submit that to the court for your viewing?
Not at this point. If it has to go to trial, all of those things, I'll take a look at them at that time. But at this point, just submit them, submit those items to the other side. Keep of course, a copy of course of whatever you send, and then engage in whatever discussions that it works out. Then counsel will be able to give you some information as to how you might not even have to deal with coming back to the next court if you got it all worked out. But that's controlled. If you don't get it worked out, everybody's to be here on the 31st at 9:30 a.m.
Thank you, Your Honor.
Thank you.
And thank you, Ms. Reed. Good day to the two of you. Thank you for your patience.
Have a great day. Thank you.
Don't think, I looked in there, one of those days I wasn't here, but the case for Miss Jessica Floyd, they don't have a notice. There's no notice.
Yeah.
There's nothing in the system. So you want me to give them a new date?
Yeah, let's give them a new date on that matter. That's what my immediate sense was, is that those date went out. And I'm referring for the record to 21-240-315. That's Jessica Floyd versus the budget lot. The court is going to renotice that matter, and a notice is going to be sent out to mail to special departments. So
what was the case number for that auto track?
I just handed you that one.
With that lady Natasha.
Oh, that was an 18 case. 18149-014.
Thank you.
And I didn't see anyone on 04-129-291. That is Midland Credit Management versus Vivian Booker. On filing of objections to a writ of garnishment. Either party appeared in that matter. Where the defendant has not appeared, the objections to the writ of garnishment will be denied at this time.
And 315, what about that one?
That's what you just gave me back. That's the renotice.
That's a renotice on the one that you're referring to now. We're given a new date. No, there was no date.
Hearing, we're talking test, she wants to know what type of hearing was for 897.
What's on here?
Yeah, it's for tomorrow.
Oh.
I got her on hold.
You should have tax testing. As a city of Detroit. Urban mobility is on there. Yeah, Timothy. I don't see. It said tax testing. The plaintiff. and then it says plaintiff two, then it has all the attorneys, and then it has defendant, suburban mobility. Robert.
All right.
Steph-
Well,
Steph- Yeah, he's the attorney.